Well, I read that the judge actually released the transcripts of that meeting.
He did, yes. The transcript was released at the end of the day, and it's like 56 pages. And I mean, it's kind of funny when people say, well, the transcript must have been redacted. So are you saying you don't see anything wrong in this transcript? Because some people, see all this witness intimidation and that kind of thing, but it doesn't quite pan out how the defense feared. Because Brian Steele had said that he'd heard from somebody who was in the meeting that Kenneth Copeland Woody had confessed to Donovan Thomas's murder, and that he'd been told he could lie on the stand and not face any repercussions. And I think, first of all, the transcript doesn't mention Donovan Thomas's murder. There are some lines in there, though, that would be really important for the defense and would be considered like potentially exculpatory evidence. There's a part where Woody asks if there's a statute of limitations for murder. And then there's another part where he's just like kind of random, and he's like, I did these crimes, though. And I'm sure we're going to be hearing about that in cross. And it kind of shows, I mean, I wonder what would have happened if Steele hadn't confronted the judge about this meeting, because would the judge have told them about this? Because I did an interview with Doug Weinstein, who's a defense attorney for Diamante Kendrick, and is actually one of the ones who filed a recusal motion against the judge. And he said he's not willing to say that the judge was never going to tell them about the ex parte hearing. So I'm like, I wonder what would have happened if they hadn't found out about it, and would this all have just remained buried, or would we have heard about it? But now that it's all coming out and they have the transcript, it's not a violation of like Brady evidence rules under Brady versus Maryland, where the prosecutors have to disclose anything potentially exculpatory, because it has been disclosed in the trial process. But it definitely got a lot of people's attention, more eyeballs on the trial.
Well, yeah, now after 18 months, the trial stopped.
Yeah.
And I don't think it's going to take that long, right?
No. In fact, the judge assigned to it has already said, she issued something, I think yesterday, saying prosecutors have until 5 p.m. on Monday to respond to the motions. And she even said that time is of the essence, because a jury trial is stalled. But one issue is the defense attorneys, there's a recusal motion actually against these judges. They think that any recusal motion against Judge Glanville should go to a judge in a neighboring court and not somebody who sits in the courthouse with them and sees them every day. So it's a question of whether the judge who's currently assigned it is going to recuse herself and send it out to another court, because obviously that'll just prolong the process. But
okay, and like you said, you don't think that the judge will actually get recused over this?
I don't think so. I think when you read through the transcript, it's unusual, and I can see why the defense attorneys are pissed and why they raised a big issue about this. But Woody's attorneys in the beginning, actually, Kayla Bumpus, who was representing Woody at the time, reads an email from Jonathan Melnick, who represented Woody earlier over the weekend. Melnick said that he might change his mind and decide to testify on Monday. And Woody has plenty of time alone with Kayla Bumpus, where he's obviously getting advice from counsel and talking about that. And when you read through the statements from the prosecutors and the judge, they're not talking to him about the substance of his testimony. They're just trying to explain to him, first of all, why he's in jail, because he asked that a bunch of times. And they're basically just trying to explain that it's contempt of court. And it is to coerce his testimony, because I think a lot of people read through the transcript and they're like, well, they're trying to coerce his testimony. It's like, well, yeah, I mean, of course they are. That's the whole point of holding him in contempt of court and putting him in jail, is to force him to testify. So I think Glanville could have just had the defense attorneys there and done all this still, but it would have been a lot more complicated. I can see, I don't know, like I said, I can see why the defense attorneys are pissed, but I don't think it's going to be anything that drives the whole case, it drives the appeal. And some of the issues or some of the things that they raised about what was said in there it doesn't quite bode out like they said. Like when you read through there, to say that he was just told that he could lie on the stand is completely not true. It's the quotes that are being screenshotted and shown about that. It's Simone Hilton, one of the prosecutors, trying to explain the difference between impeachment and prior inconsistent statements and then just straight perjury. And he is told multiple times that he could be prosecuted for perjury, that he can't just get up there and lie, but that if she's impeaching him for inconsistent statements, then it's not going to be the same as perjury. It's just a little bit different. I think he's And the way Glanville has approached it all, I think in the beginning it was kind of weird that he didn't just tell the defense attorneys about it, but especially the fact that the transcript's been released, they can use it in cross. I mean, all this stuff. I don't see it's just going to be looked at as a trial decision by a judge and not anything that shows any kind of personal bias against the defendants.
Okay, because the way it's been reported was, did YSL Woody admit to killing Donovan Thomas, aka Nut, or not?
No, well, no. I mean, I think Brian Steele said that, yeah, he heard that he admitted to killing Donovan Thomas. But if you read through the transcript, they never mentioned Donovan Thomas in this transcript. But there's that line about I did these crimes, and then he asked about the statute of limitations for murder. So you can see things in there that will be helpful for their defense in their argument that he did kill Donovan Thomas. But no, I would say it's a pretty big mischaracterization of what was said in there to say that he just confessed to killing Donovan Thomas. No, he didn't. But also, I think a lot of people like to focus on that, I did these crimes. But when you look at everything that happened around that, it was just kind of like, but they'll get a chance to explore that in cross-examination, which should be pretty interesting.
I mean, yeah, they're saying this trial is going into 2025.
Yeah, which I just think is crazy. And I've always thought that the jury will drop out. Like, how can you have 12 people, or I think they have like 14, 16 now, with some alternates? How can you expect all those people to just, sit and listen to this trial and not have anything come up in their lives that prevents them from doing this? But the way Judge Glanville is, I think if any of those people try to drop out, he's going to like jail them for contempt. So maybe they won't drop out. And right now, I think they still have, is it 14 or more than 14, 15, 16? Gosh, I don't know. I mean, they still have a few extras, so we're not at that point yet. But I get a little frustrated with all the people who say mistrial, 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 because they're frankly just kind of misusing the word. But the only person right now who can call it mistrial in this is Judge Glanville, and he's not going to unless he absolutely has to, and that the jury drops out. But I think we're just kind of in for it, for at least through the end of the year.